Hi guys, I hope all of you are well and life is well and you are well and everybody is well. So in today's video we are going to be talking about the case laws that are most important, the judgments that are going to be the most important judgments for your MHCET examination, because as all of you know, in the MHCET exam they can ask you questions related to the judgments, like legal GK related question, in which case this was established. So therefore it is essential to understand those case laws that are the most essential for MHCET exam. So if any of you is preparing for the MHCET exam, then we have the PRAGATI batch for the MHCET exam, in which you can enroll yourself if you are preparing for MHCET and you wish to prepare in a more structured manner. It is a complete batch in which all your 5 subjects will be completed. The classes shall be in the evening. You will get mock tests, sectional tests to practice from the comfort of your house. So if you are looking for preparation for MHCET, then you can enroll in this course and come to the classes and complete your syllabus and give the MHCET examination. If you like my teaching method, you can use my code, which is Kriti B, for additional discount on the PRAGATI batch. How will you access the batch? So you can visit the website 12minutes2clat.com, or the description box also has the link. These are the MHCET 2024 results if you wish to see, and I hope your name is here in the MHCET 2025 results as well. So you can enroll with us and your syllabus shall be completed with us. These are some more of the MHCET 2024 results. In case you have any doubt with regard to the MHCET exam and the batch, then you can contact on these numbers and get your doubts cleared on WhatsApp or on call. You can download our app from the App Store or the Play Store by searching the name of the app, which is 12 minutes to CLAT. So alright guys, let us talk about the most important case laws that you should know while preparing for the MHCET examination related to legal reasoning. So we'll be discussing the 4 laws separately. Sorry. Important case laws in law of tort, important case laws in contract law, important case laws in criminal law, and important case laws in constitutional law. The most important ones we will be discussing in today's class. So let's start the most important case law under tort law, Donog versus Stevenson. Now I am sure that all of you would know about this case. This case relates to the principle of negligence. So what is negligence? Negligence means carelessness. Whenever there is carelessness on the part of a person, what is carelessness? Where a person does not do his legal duty, which causes damage to others. Then in that particular case, it results into negligence, which is one of the tort. Now what happened in Donog versus Stevenson? 2 people went to have some drinks, and one of the friend, she ordered a drink which was a ginger beer, and when she so it was an opaque bottle. When she was served with the ginger beer, it was an opaque bottle, so she could not have realized that what are the contents of the bottle. When she consumed half of the ginger beer, then she thought that she will drink it from a glass, and poured the rest of the contents of the bottle in a glass. As soon as she poured it, she found a snail inside the bottle, like which got transferred to the glass, and she started feeling nauseous and she had to be hospitalized due to stomach infection. She filed a case against the manufacturer for negligence. Court said yes, definitely it is going to fall under negligence, because any person who is providing any eatable to another does have a legal duty to provide consumable products and not products which have insects or animals within it. So definitely there is negligence on the part of the manufacturer. Also another question in this case was that why does this not fall under law of contract, because the woman got something and she paid for it, because she herself did not buy it. Her friend bought the ginger beer on her behalf. So therefore this will not fall under contract law and only fall under tort law. That is the first case. Second most important case is going to be Ryland versus Fletcher. Again, a very important case under tort law which established the principle of strict liability. What is strict liability? Strict liability is a principle which has three essentials which say that if any person brings onto his property anything that is dangerous and that dangerous thing escapes from the property and it was a non-natural use of land, then in that particular case the owner, even if had no fault in making the dangerous thing escape, will be liable for the loss caused to others. This is also called as no fault liability. In this case, a man built a water reservoir on his property. There were certain shafts below the water reservoir. The water protruded into the shafts and went to the neighbor's property, which was of coal mines, and all the coal mines got flooded. Even though the owner of the water reservoir property had no idea, he was held liable under strict liability because keeping such amount of water is a dangerous activity which escaped and which was a non-natural use of land. Third important case is MC Mehta versus Union of India, the case in which absolute liability was established as a liability first time. It is an Indian case, also known as the oleum gas leak case. What is absolute liability? Absolute liability says that if any enterprise does anything which is dangerous, causing damage to others, then the enterprise shall be liable absolutely with or without fault, without any exceptions. Strict liability has 5 exceptions. Absolute liability has no exceptions. So in this case, in Delhi actually, oleum gas got leaked from a factory and caused harm to people in the surrounding area. So Supreme Court established the absolute liability doctrine and said that the factory shall be liable, whether they did something or not do something doesn't matter. They were an enterprise who were doing something dangerous, definitely they will be liable. Fourth case under law of tort, Indian Medical Association versus VP Shanta. In this particular case, basically talks about medical negligence per se, not just negligence. What is medical negligence? Whenever carelessness is shown by any medical professional, by any chemist, doctor, surgeon, nurse, then it falls under medical negligence. So due to a doctor's negligence, यहाँ पे a patient suffered, court definitely said that this also falls under Consumer Protection Act and negligence per se, and definitely the doctor shall be held liable. Then Grant versus Australian Knitting Mills. In this case, the concept of product liability was established, that if any product causes damage to others due to its use, causes damage to others, then the person who has sold off such products will be liable. So in this case, a man bought certain undergarments and suffered from a skin infection by using the undergarments and filed a case against the manufacturer. Court definitely said the manufacturers will be held liable because they owed a duty of care. Next, State of Rajasthan versus VIJAYI. This is the case which established sovereign immunity, basically was related to the concept of sovereign immunity. So court in this particular case said that the government can be held liable for the acts committed by its servant. So if any government employee commits any tort, then when will be the situation where the government can be made liable. So basically the government has two types of functions, sovereign functions and non-sovereign functions. Sovereign function means functions that are supreme, that are only performed by government. If the employee was performing a sovereign function, government is not liable. Non-sovereign function means functions that can be performed by private bodies as well and are commercial in nature. For example, banking, school, hospitals. In non-sovereign function, if negligence occurs by the employee, the government can be made liable under vicarious liability. Next, Blue Coaster grammar case. I am sure everybody would have heard about this case. So this basically realizes the principle damnum sine injuria. Damnum means damage, sine means without, and injuria means injury, damage without injury. So this principle says that if any damage occurs to another person but their legal right is not violated, then no case will sustain in a court of law. So in this case, a school was set up right in front of another school. All the students from that school went to the new school. So the owner of the previous school filed a case against the new school owner, saying that he has taken away all the students and caused me financial harm. Court said that there is no legal right violation in this case. Therefore, the owner of the new school is not liable. Similar case related to similar principle is Ashby versus White, dealing with the principle injuria sine damnum, injury without damage. This principle says that if a person's legal right is violated, even if no damage occurs, then a case under tort can still be filed. So here, right to vote was denied to a person, even though that person suffered from no financial or physical harm. Court said still there is a legal right violation. Tort law will sustain, a case under tort law will definitely sustain. Next is the Union Carbide Corporation versus Union of India, Bhopal gas tragedy case. So in this case, the concept was that if on such a large scale, something of that sort happens wherein a gas is leaked through an enterprise and harms the whole city and has huge repercussions. So basically the principle of corporate liability in mass tort cases was established. Court said that compensation will definitely be ordered because this is a mass leak and the whole city has suffered. Definitely compensation needs to be paid. K.S. Puttaswamy versus Union of India talks about right to privacy. Every person has a right to privacy. It is one of the legal rights present in this country. If that is being taken away, remedies can be asked under tort law. Coming to contract law important cases, Carlyle versus Carbolic Smoke Ball Company. So this case basically establishes the principle of general offer. What is a general offer? An offer meant for anyone who fulfills the conditions of the offer. So what happened in this case was that there was a company which put out an offer in the newspaper. Anybody who uses our product and still suffers from influenza will get a reward. Now a woman used that product and still did suffer from influenza, filed a case against the company. The company said we can't be liable because we did not ever deal with you. We did not ever dealt specifically with this woman, so there can't be a contract. But the court said no, the advertisement given by the company was a general offer, a unilateral offer, and she completed all the conditions of the offer and therefore there is acceptance, it is valid. Balfour versus Balfour, very interesting case. Basically, this case talks about the principle that domestic agreements are not enforceable, social agreements are not enforceable. So a husband in this case promised his wife to send some money while he was away. When he stopped paying, the wife filed a case against him for compensation. Court said there is no contract between husband and wife, there is no legal intention. Mohri Bibi versus Damodar Ghosh is the case which said that a contract with a minor is void ab initio, is not enforceable in any court of law. Ab initio means since the beginning. Hadley versus Baxendale talks about remoteness of damages. How much damages can a person be sued for? How much damages, till what length can you sue a person? So here a miller sued for lost profits when a delayed shipment of a broken crankshaft halted production. Court said that not all damages can be covered, not damages that are far-fetched, they can't be covered. Damages are only recoverable if they arise naturally or were contemplated by both parties at the time of the contract. Lalman Shukla versus Gauri Dutt. So this case realizes the principle that acceptance must be communicated. So there was an offer that whoever finds this lost child will be given X amount of money in the newspaper. The person who has put up that offer also sent his servant to find the child to go and look for the child. Without knowing about the offer, the servant went to look for the child and brought him back. Later, the servant got to know about the offer and asked for the reward. But there was no contract between him and the person who gave the advertisement, because he was unaware about the offer when he got the child back. Dunlop Pneumatic Tire Company versus Selfridge Limited talks about privity of contract. Only parties to the contract can sue on the contract. No third person can sue. Chinnaya versus Ramaya establishes the principle that consideration can come from a third party. So in this case, a woman gifted some property to her daughter on the promise that daughter will give some money to her brother. In this case, again, the court said that consideration can come from a third party. So India does not believe in privity of consideration, only privity of contract. Gherulal Parak versus Mahedeo Das Maya, agreements against public policy are void. So in this case, a contract for wagering was declared as void because they are against public policy. Kedarnath versus Gauri Muhammad talks about the principle of promissory estoppel, saying that if someone does something on a promise made by you and someone acted on that promise, then the promisor can be bound even without any traditional consideration involved. So here a contractor started some work because people promised him that they will give him funds, and they then later said, we will not pay you any money. Court said you will have to pay money because on your promise the contractor started the work. Bhagwan Das versus Girdhari Lal so talks about the principle when a contract is concluded in electronic or telephonic communication. So over the telephone, basically talks about where is the jurisdiction of the case. Court said that wherever acceptance is received by the offerer, that is when the contract is concluded in case of telephonic communication, when the offerer hears the acceptance. Coming to criminal law cases, so R versus Prince establishes strict liability in criminal law, that accused took a girl under 16 believing she was above 18. Court said that he will be held liable irrespective whether he knew the actual age or not, the girl lied or not. So in some cases, mens rea may not be required. Second case is KM Nanavati versus State of Maharashtra. On this case, the Rustam movie was based. Basically, a man killed his friend after getting to know that he has an extramarital affair with his wife. So again, the question was that whether such case can fall under the exception of grave and sudden provocation. Later, definitely the court said that this should fall under murder, because in this particular case, the husband took time to go and find the friend and then kill him, which is more planned. Third is State of Maharashtra versus M.H. George, talks about presumption of mens rea. So in economic offences, mens rea is not necessary. In this case, a man was carrying gold without knowing that that much amount of gold is not allowed. Court said he is liable. Whether he knows or not doesn't matter. R versus Dudley and Stephens, very very important case. In this case, a boy was killed because there were certain people on a ship and all of them would have died had they not killed the boy and ate him. Court said that no necessity as a defense shall be provided. Tukaram versus State of Maharashtra talks about consent in rape cases. Court said that if a woman does not resist, does not always mean that she was consenting to the sexual intercourse. Keher Singh versus State, Indira Gandhi assassination case, talks about criminal conspiracy. Court said that mere presence in a conspiracy can make a person liable if proven in a court of law that he was a part of the conspiracy. Salvi versus State of Karnataka, right against self-incrimination, talks about whether narco-analysis or tests like lie detector test should be allowed on a person without permission or not. Court said that it is unconstitutional, permission should be necessary. And death penalty case is Bachchan Singh versus State of Punjab. Court established the rarest of rare doctrine, saying death penalty will only be given in rarest of rare circumstance case. Union Carbide Corporation versus Union of India relates to the Bhopal Gas Tragedy case. Again talks about corporate criminal liability. MC Mehta versus Union of India talks about absolute liability in criminal sense as well. And Shreya Singhal versus Union of India, very very important case, talks about striking down section 66A of the IT Act, which said that any person who writes anything online which can hurt sentiments can be made liable. This is a very vague definition and therefore it was removed. Coming to constitutional law, Keshav Nanda Bharti versus State of Kerala established the basic structure doctrine. So in this case, basically it was said that there are certain features of the constitution that can never be amended. So it said that the whole constitution can be amended, even the fundamental rights chapter, right to equality article, right to religion article, right to constitutional remedies article, every article in the constitution can be amended, but the basic structure of the constitution cannot be amended, which has certain features, for example judicial review, democracy, secularism, federalism, universal adult franchise. So these are certain features that cannot be amended. The article can be amended but not the essence of the features. Very very important case. Second, A.K. Gopalan versus State of Madras limited the scope of fundamental rights. This case was later overruled. Basically this case, the Supreme Court held that each fundamental right is separate, limiting the scope of protection. But this basically, if one article is violated does not mean necessarily the other will be violated, but this was overruled in the Maneka Gandhi case later. Maneka Gandhi versus Union of India said that there is a golden triangle principle, saying that whenever Article 14 is violated, then Article 19 and Article 21 are violated automatically, and vice versa. Basically, these three fundamental rights are interconnected to each other under the golden triangle principle. So this is also the case which established this principle. Minerva Mills versus Union of India strengthened the concept of basic structure principle. The Supreme Court said that if destroying fundamental rights violate the basic structure, basically a particular amendment was done under Article 368, which said that if any amendment is done by the Parliament, it cannot be questioned in a court of law. Court said no, judicial review is a part of basic structure. No amendment can take away the right of judicial review. So court struck down that amendment which took away the power of judicial review from court. Golaknath versus State of Punjab, fundamental rights cannot be amended, was established in this case. Again, this case was also overruled. In Keshav Nanda Bharti case, court said no, the whole constitution can be amended, even the fundamental rights, except the basic structure part. I.R. Koholo versus State of Tamil Nadu is a case related to judicial review. So, because the Parliament wanted certain laws to not be challenged in a court of law, so the Parliament added 9th schedule in the Constitution and said any act which falls under 9th schedule cannot be challenged in a court of law. Again, court said that every act made by the Parliament can be challenged in a court of law, because judicial review is a basic structure. So it does not matter you have added an act in 9th schedule. After Keshav Nanda Bharti case, even if any act is added under 9th schedule, it can be challenged. Indira Gandhi versus Raj Narayan, rule of law and free elections related case, the court said that elections must be fair and just. No person should hamper the elections in India. So free and fair elections was established in this case. S.R. Bomai versus Union of India talks about precedent's rule in a state. Court said that continuous precedent rule in a particular state is a fraud on the constitution and a misuse of power of the constitution. If any state has been suffering from precedent's rule again and again, that is a fraud and shall not be allowed, and therefore judicial review of precedent's rule can be done. Vishakha versus State of Rajasthan talks about the sexual harassment guidelines at workplace. Now we have an act also for this. So Sexual Harassment at Workplace Act is based on these guidelines given by the Supreme Court in the Vishakha case. KS Kudduswamy versus Union of India talks about right to privacy. That right to privacy is a part of right to life, Article 21 itself. So these were some of the most important case laws related to the 4 laws. That is all for today, guys. I hope this was helpful. Make sure that you have understood that what is there in each case and what was the judgment of each case in one line, of course, because your question paper may ask you in which case it was established that right to privacy is a part of fundamental rights of India, is a part of Article 21. So it is going to be KS Kudduswamy versus Union of India, and similarly all other cases can also be asked. So in case you have any doubt, you can ask me in the comment section. Thank you so much. Have a great day. Have a great week ahead, and I'll see you all next week. Take care and bye, guys.